Good afternoon, everyone, and welcome to the 28th Annual Merv Leitch QC Memorial Lecture. My name is Paul Payton, and since 2014, it's been my privilege to serve as Dean of the Faculty of Law here at the University of Alberta. One of the more pleasant duties I've had as Dean has been to select the speaker in alternating years for this prestigious lecture. As you may be aware, the lecture is shared with the University of Calgary's Faculty of Law. During my time as Dean, we've hosted pollster Nick Nanos, former Privacy Commissioner David Lukadelis, former U.S. Ambassador to Canada Gordon Giffen, and noted political operative and pundit Warren Kinsella. A thread running through all of these lectures has been the ethical challenges facing those in public office and public life, and how we as lawyers and as citizens might best respond to those challenges. Given that my own research and teaching interests focus primarily on ethics for lawyers, ethics in corporate contexts, comparative regulation, and ethics in government, it's with special pride that in this, my last year of my deanship and organizing the Leitch lecture here, I'm able to introduce this year's distinguished speaker. Richard Painter is the S. Walter Ritchie Professor of Corporate Law at the University of Minnesota Law School, former White House Ethics Counsel during the presidency of George W. Bush, and noted commentator. I'm delighted to welcome him here today to the University of Alberta Faculty of Law for his lecture, Conflicts of Interest, Investigations, and Ethics, I'd add question mark, in the Age of Trump. Before a more in-depth introduction of Professor Painter, I have a few acknowledgements that I'd like to make before we start today. In particular, I want to acknowledge members of the Leitch family who are joining us this afternoon. Jim Leitch, Shannon Dean, Jan O'Neill, Brian O'Neill, Kathy Glover, Clancy Glover, Laura Glover, Scott Sandeman Allen, and Taylor Sandeman Allen. It's especially important for us to have this living legacy and to have this continuing connection, and we welcome you all here again this afternoon. I'd also like to acknowledge a number of distinguished members who may or may not, of the judiciary, who may or may not have made it onto my list. I note the Honorable Alan Walkowicz. Thank you very much, Chief Justice Walkowicz, for joining us. And to all of the distinguished members of the judiciary, those in government, and students, faculty, staff, alumni, and members of the legal community, as well as members of the public. Thank you for joining us for this lecture as we honor the memory of Clarence Mervyn Leitch, QC, a truly great Albertan. Since 1991, the Merv Leitch QC Memorial Lecture has been delivered annually to audiences at both the University of Alberta and University of Calgary faculties of law. The lecture series was established by former Premier of Alberta, the late Peter Lougheed, and other friends and associates in honor of Merv Leitch, who passed away in 1990. It attracts eminent speakers to address the community on a topic of public importance and reflects the significant contributions Mr. Leitch made while serving his fellow Albertans locally, provincially, and nationally. Mr. Leitch served in the Royal Canadian Navy and then became a high-profile lawyer and partner with a firm formerly known as McLeod Dixon, now part of Norton Rose Fulbright Canada LLP. Mr. Leitch was president of the Calgary Bar Association and a bencher of the Law Society of Alberta. He entered politics in 1971, was promptly elected to government as a member of Peter Lougheed's Progressive Conservative Caucus, which swept into power in Alberta that year. Between 1971 and 1982, his cabinet positions included Attorney General, Provincial Treasurer, and Minister of Energy and Natural Resources. In addition to acting as a director for several Canadian corporations, he was also on the board of the Canadian Institute of Resources Law at the University of Calgary. Mr. Leitch has many stewards of his memory with us here today and indeed throughout the province. In addition to creating this lecture series in his honor, those closest to him also endowed the Merv Leitch QC Prize and the Merv Leitch QC Leadership Scholarship in Law at both the University of Alberta and the University of Calgary. And I want to take a moment to recognize this year's UAlberta Law recipients. You know, one is here this afternoon, one was ill, and the other two were supposed to be on their way, so we'll see. The Merv Leitch QC Prize is awarded annually to a student entering his or her second year of law, based on superior academic standing in the first year of the constitutional law course and demonstrated participation in extracurricular activities. I'm very pleased to announce that the 2018-19 recipients of the prize are Adam Kotlowitz and Shanoa Sai. Shanoa, congratulations. The Merv Leitch QC Leadership Scholarship in Law is awarded annually to students with superior academic achievement entering the first year at the Faculty of Law. Recipients are selected on the basis of demonstrated participation in community service or extracurricular activities and academic standing achieved during pre-law studies. I'm very pleased to announce that the 2018-19 recipients of the scholarship at the University of Alberta are Alexa LaPlante, who's ill and couldn't be with us this afternoon, and Kristen Reibold. Please join me in congratulating both of them. Before I turn to introducing our guest speaker today, a few administrative matters. First off, following the lecture, everyone is invited to a reception to meet our guest speaker and to continue the conversation. The reception will take place in CN Alumni Hall, which as you exit the lecture hall is up the stairs about half a level. Please ask anybody if you can't find it. We'll hopefully follow the crowd on the way up there. Please join us afterwards for some conversation and a chance to speak with Professor Painter directly. You'll notice that there are some index cards and pens scattered throughout the room. For the question and answer session that will immediately follow the lecture, we'd invite you to write down your question and send it to the end of your row where a volunteer will collect them. I'll moderate the session with Professor Painter and draw on your questions and a few others that we have prepared. If you don't have the chance to ask your question posed or it gets amalgamated with others, please feel free to talk to Professor Painter at the reception following the event. One other note, we are live streaming this event and the video will be archived and available online afterwards. Govern yourselves accordingly. And with that, I have the happy pleasure of turning to introduce our esteemed Leitch lecturer this year, Richard Painter. I would like to think that I had a crystal ball or perhaps unique connection to the Russians when selecting both the topic and the date for these lectures this year. Who knew that ethics in the age of Trump, and in particular the delivery of the Muller Report, would be on the front page of every major newspaper and on every broadcast as the world, and frankly every commentator, tries to dissect the 4-page letter from the new US Attorney General that, quote unquote, summarized the report and in many respects, frankly, raised more questions than it answered. What does it mean, as the New York Times reported today, to have Mr. Barr write that on questions of President Trump's involvement in the obstruction of justice, quote, Mr. Mueller left that question unresolved, instead stating that, quote, while this report does not conclude that the president committed a crime, it also does not exonerate him, end quote, according to a brief excerpt from the special counsel report that Mr. Barr quoted. With Mr. Rosenstein's concurrence, Mr. Barr embraced that opening to declare that the president broke no law, end quote. Recent political events and socioeconomic stressors that are affecting countries across the globe, and particularly in the United States, have produced unprecedented actions from many elected officials. Some of this conduct has been seen as undermining prevailing norms and corroding civil institutions. History will decide how it will be considered, but it does challenge the definition each of us holds for what is ethical. When I first started as dean, concepts such as the rule of law were ordinarily the subject of highfalutin rhetoric or legal philosophy, something that your dean talked to you about on the first day of law school, and then you might have figured it out 3 years later that it had some importance. Fast forward 5 years, threats to the rule of law and its fundamental importance to our democratic institutions and are now the stuff of conversations of ordinary citizens, much more frequently than ever before. Even in Canada, with the SNC-Lavalin episode continuing to unfold, we're now participants, not simply observers. 3 weeks ago in this space, I hosted the new Attorney General and Minister of Justice, David Lametti, just about 90 days after hosting former Attorney General and Minister of Justice, Jody Raybould-Wilson. It's been quite the year. And we've been privileged to have such experts and players join us to share their perspectives. I'd promised when I started as dean to reconnect the faculty to the profession, to the judiciary, and to the public as a resource for thinking and learning about the law. And we've been extraordinarily privileged over these 5 years to be able to bring leaders to help us aid in that mission. Today, in Conflicts of Interest, Investigations, and Ethics in the Age of Trump, Professor Painter asks why we should care about questions of ethics in this volatile political climate. He considers what can be done to immediately address these issues, how we can create stronger ethical boundaries for the future protection of our institutions, and how we might move forward. Professor Painter is known to many of you from his numerous appearances on MSNBC and CNN and elsewhere, But I've known him almost as long as I've been in the academy, as a go-to authority on government ethics, securities litigation, and the role of corporate attorneys in corporate governance. Indeed, some of the earliest work that I'd done in 2001, 2002 on lawyers, ethics, and Enron was informed by Professor Painter's academic and advocacy work. In particular, articles and submissions that he authored that called for what eventually became a key provision of the Sarbanes-Oxley Act of 2002, requiring the Securities and Exchange Commission to issue rules of professional responsibility for lawyers appearing and practicing before the Commission. As you will have seen from his media appearances, he's deeply passionate about holding public officials and politicians accountable for corrupt behavior and bringing their conduct to the public attention. Professor Painter received his BA in History, summa cum laude, from Harvard and his JD from Yale. Following law school, he clerked for the U.S. Court of Appeal for the Ninth Circuit, practiced at law firms in New York City and Connecticut, before becoming a faculty member at the University of Oregon and subsequently thereafter the University of Illinois College of Law. Before he was at Illinois immediately before joining the University of Minnesota, where he now is. From 2005 to 2007, he was associate counsel in the White House counsel's office, serving as chief ethics lawyer for the president, White House employees, and senior nominees to Senate-confirmed positions in the executive branch. In 2014 and 15, he was a residential fellow at the Harvard University's Safra Center for Ethics. He's a board member for the Citizens for Responsibility and Ethics in Washington, or CREW, which is a watchdog organization that uses litigation to hold public officials and politicians accountable for unethical and illegal behavior. He's also a founding member of Take Back Our Republic, a campaign finance reform organization. A member of the American Law Institute and a reporter for its new Principles of Government Ethics, he's been active in the professional responsibility section of the American Bar Association and in many efforts to engage in law reform. On multiple occasions, he's provided invited testimony before both chambers of the U.S. Congress on government ethics, securities litigation, and corporate governance. He's the author or co-author of several books and casebooks. He's written dozens of articles and op-eds for publications such as the New York Times, Washington Post, USA Today, and others. And interestingly, becoming a player can sometimes turn into something different. Last year, he contested the Democratic primary to fill a Senate seat in Minnesota to replace Senator Al Franken. I know we'll have a few questions about that a little later on. We are absolutely delighted to have Richard Painter join us here this afternoon. It's great pride and anticipation that I'm very pleased to welcome the 28th Annual Merv Leitch Lecturer, Professor Richard Painter.
Thank you. Thank you, Paul. Yeah, we'll talk about that Senate race later. Paul mentioned that I taught at the University of Illinois in Urbana-Champaign. Wonderful place. I actually grew up there. I was born in Philadelphia, but my father was also a law professor at the University of Illinois in Urbana-Champaign, and I moved there in 1972. I learned a lot about government ethics in Illinois growing up. The governor then was a man named Dan Walker, who later went to jail. I think that's part of a Illinois governor's resume, going to jail. And by the time I left Illinois for the White House, or I guess it was a few years after that, we had two governors from Illinois, one Democrat and one Republican, serving their terms concurrently in the federal penitentiary. Governor Blagojevich is hoping for a Trump pardon. I don't know what's going to happen with that. But I certainly saw a lot of interesting things going on at the state level. And then I went to the Bush administration. I certainly had some very interesting experiences there. And I'll refer to some of those in the course of my lecture today. What I'd like to do is break this lecture into two parts. First, address financial conflicts of interest for government officials. And I'm going to be looking mostly to the situation in the United States, but I would welcome discussion in the question and answer time about what's going on in Canada with respect to conflicts of interest, financial conflicts of interest for government officials. And then I want to turn, of course, to investigations and prosecutions, which is a very, very live issue, both in the United States with the delivery of the Muller Report in the past few days, and of course here in Canada with some scandals here as well, which I'm not going to go into in great detail, but I think there's some principles here that we can talk about with respect to prosecutorial independence and how investigations should be conducted, and departures from that norm, which I think have been quite extreme in our country and in some of the situations taking place here in Canada. Worrisome, although I don't think, at least from what I'm reading in the papers, is extreme as what we've had to confront in the United States. Let's start with financial conflicts of interest for government officials. What are the financial conflicts of interest that are most likely to endanger a democracy? The founders of the United States, with the drafters of the Constitution, identified some of those financial conflicts of interest and not others. So they got it right on some things and wrong on others. Let's start with what they got right. The founders of the United States, well aware, when they drafted the Constitution, that foreign governments were a source of corruption. And already in Europe, there have been foreign governments bribing officials in other governments. The French had bribed members of parliament. In the UK, the French king, and of course the King of Great Britain was also busy bribing the members of his own parliament. But competing with the French king made things much more complex. And Edmund Burke spoke on the floor of the House of Commons about the corruption of the members of the House by the King of England and also other foreign leaders. It was a serious problem. And the founders of the United States knew that there would be no point fighting an American Revolution, heaving the British tea into Boston Harbor, having a new government, a constitution, if you could have members of the United States government, whether it be the president, the members of Congress, or anyone else, who was receiving payments, gifts, profits or benefits, meaning emoluments, from foreign governments. And they put a provision in the United States Constitution to address that, the so-called emoluments clause. And this was a genuine worry because the great powers of Europe had considerably more concentration of wealth than there was in the hands of the United States government. The great powers, the great empires, they were constantly interfering in other countries' business and politics. Were Great Britain, the British Empire, the French Empire, the Austro-Hungarian Empire, and there's a fourth one, Russia. Yeah, they were good at it even way back then. And once again, in every one of those countries, enormous concentration of wealth in the hands of the crown, of the government, and the ability of the government to influence through money what goes on in other countries, and the founders of the United States did not want it here. And that's why there is a provision in the Constitution which prohibits any person holding a position of trust with the United States government from accepting from any foreign government a present or gift, an office. You can't serve in the United States government, serve in another government as well, a title, or an emolument. And you look at Dr. Samuel Johnson's 1755 Dictionary of the English Language, and an emolument is a profit or benefit. It's not what the United States Department of Justice at taxpayer expense is not trying to convince the federal courts it is. It's what the dictionary says it is. I'm sure the late Justice Scalia would agree with my approach here, I would hope. And so this is a critically important part of the Constitution. By the way, there's another provision in the United States Constitution which addresses the founders' fear of foreign government infiltration of the United States government. And that is the provision that says that the President of the United States, that one office, the most powerful office in the United States, the President of the United States must be a natural-born citizen. The founders were scared of the idea that someone could come over from Great Britain or anywhere else with a boatload of cash from who knows where and work their way up the political system. Yes, money gets what you want in politics, then as now, and then become President of the United States and then be beholden to a foreign country. So the President of the United States must be a natural-born citizen. We certainly heard a lot about that from Donald Trump because he had all sorts of stories to tell about Barack Obama's birth certificate, even though Barack Obama was born in Hawaii, which is, everyone knows, one of our 50 states. But that doesn't prevent alternative facts from making their way around the media. So we heard a lot about that. And that's the great irony here. And then we actually confront a serious constitutional problem with respect to foreign governments under the Emoluments Clause of the Constitution. Because President Trump is one of the first presidents, the only president, that had a substantial engagement with the Emoluments Clause. All the other examples have been really quite small. And what he has done is not gone to get permission from Congress, which is what's required of the Emoluments Clause. If you want to take that emolument, that profit or benefit from a foreign government, you must go get permission from Congress. And he has not done that. He did not do that when there was a Republican-controlled Congress. Why? Because the Republicans didn't want to take ownership of this situation any more than anyone else would. They might want to see the tax returns first. They weren't there. They weren't going to be shown. Well, they weren't going to give him any clearance on his emoluments. They say, you're on your own. So he never went to Congress for permission. We have not only the money coming into the Trump hotels when foreign governments book rooms in the Trump hotels and they book the ballrooms for big events and all that. That's the surface level emoluments. The real action is in the business empire, the Trump business empire. We do not know what's there. Now, maybe if we got the entire Muller report, there might be some discussion of what's there if it has anything to do with Russia. But there's some other countries in the world that we might be concerned about that Bob Mueller had no responsibility for investigating, for example, Saudi Arabia. But the fact of the matter is that a financial empire of the size of Donald Trump's involves a lot of financing, a lot of borrowing. We know one thing about President Trump is around 1993, the year I left New York law practice at Sullivan and Cromwell, I left New York to go into law teaching in 1993. Right about then is when all the New York banks cut Donald Trump off because he didn't pay them back. There's something about New York bankers, just like bankers in Minneapolis, they like being paid back. And they weren't. $900 million worth of casino bonds. So we do not know where Donald Trump is borrowing his money. It's all borrowed at the corporate level. None of that's disclosed because it's all at the corporate level. He doesn't borrow it himself. So that is a concern in the United States. And this is unique in our history. We have never had this level of concern about foreign business entanglements of the President of the United States. But this is a matter the founders identified as a serious threat, and that's why they put the Emoluments Clause in the Constitution. Now, one of the problems we have, though, is there's no provision for enforcing the Emoluments Clause in the Constitution. There's the Impeachment Clause, which would allow the House by majority vote and then the Senate by 2/3 to remove a President of the United States or other official through the process of impeachment, and presumably violation of the Emoluments Clause or any other provision of the Constitution might very well constitute cause for impeachment. But other than that, there is no provision for enforcement of the Emoluments Clause. I have been part of a legal team that has brought lawsuits in the federal district courts seeking judicial discovery orders, finding out what money is coming into the Trump business empire. There are 3 cases pending, but there are going to be standing issues with all 3 of them. And standing, of course, is the question of who gets to go into a federal court and complain about something. If everybody who had a complaint about Donald Trump got to go and file a case in federal court, well, we wouldn't have any place to put the clerk. There'd be so much paper flying around. So you've got to have some standing restrictions. Our organization, Citizens for Responsibility and Ethics in Washington, filed in New York. The judge in New York felt we did not have standing. We're appealing to the Second Circuit. The Attorney General of the state of Maryland and the Attorney General of the District of Columbia filed another case in Maryland, and the federal district judge felt they did have standing. And also the Maryland federal district judge, in the first ever interpretation of the Emoluments Clause by a federal court ever, sided with the position that I took in my paper with Norman Eisen and Lawrence Tribe, interpreting the Emoluments Clause. That paper is up on the Brookings Institution website, that it essentially is profits and benefits, the dictionary definition, not the much narrower definition that the Department of Justice is urging. So that's the Maryland litigation. That's on appeal to the Fourth Circuit, which is a very conservative circuit. So there's some very skeptical questions asked the other day by the judges of the Fourth Circuit. And regardless of who wins there, that one's likely to go on up to the Supreme Court. And then a third suit brought by the Democrats in the House and the Senate, led by Senator Blumenthal of Connecticut, who read the Emoluments Clause and said, well, the Emoluments Clause that says you cannot accept the emolument, the profit or benefit, unless you get consent of Congress. They never asked us. So we get to sue. We have standing to sue. That's in the District of Columbia. Federal courts, I believe the district judge said they have standing, and that'll work its way up through the system as well. Now, of course, with the House of Representatives having changed hands, we have a House Judiciary Committee that may very well swing into action and focus on profits and benefits from foreign governments that are being received by the president, or they could be looking at the Kushner family, because this clause applies to every single person holding a position of trust with the United States government. And they've served a lot of subpoenas. So let's see what happens with that. But it's critically important. This is the independence of the United States is in danger if you have foreign governments who can create relationships of financial dependency with anyone in the United States government, much less the President of the United States. So the founders identified that conflict. They completely missed the boat on other conflicts. For example, financial conflicts of interest that are domestic inside the United States from businesses owned by government officials, members of the United States House, members of the United States Senate, and the President and the Vice President. And I was reminded of this when President Trump very quickly reacted to the accusation of financial conflict of interest because of the Trump business empire. And a number of us had said he needs to divest the Trump business empire and sell the hotels or get rid of it in order to not have conflicts of interest. And we all reminded him of how Jimmy Carter sold his peanut farm to be president. And this Trump business empire is no peanut farm. So what was the reaction, though, of President Trump? He said, well, I'm thrilled the president can't have a conflict of interest. Oh, I didn't know that. And then he gives us a history lesson. Well, President Washington went home and visited Mount Vernon. And then the third president of the United States, Thomas Jefferson, had Monticello. And they kept their plantations. And, of course, they wouldn't be unethical. George Washington, Thomas Jefferson, they kept their plantations. You say, wait a minute, let's slow down here a bit. Now, I think George Washington and Thomas Jefferson are two of our greatest presidents in many, many ways. But they weren't perfect, and they had one great imperfection, one great sin, I would call it, that has caused enormous damage to America. And it was those plantations that were using slave labor. And the history of slavery in the United States and the racism that comes out of the slavery experience is not just about racism, that is a large part of it, but also financial conflicts of interest of presidents, vice presidents, senators, members of the United States House of Representatives who had a financial interest drafters of the Constitution who had a financial interest in the slavery system. These were very large establishments, the plantations owned particularly by George Washington and Thomas Jefferson. George Washington was one of our richest presidents. If you look at the value at the time, what he had. Financial conflicts of interest can have tragic consequences for a country. And probably the most tragic part of American history comes out of not only our history of racism, but the financial conflicts of interest of very, very powerful people at the beginning of our country's existence all the way through the first century. So for President Trump to so quickly refer to that as an example makes me shudder and think, well, financial conflicts of interest we need to take seriously. And to this day, we do not have any provision in the United States Code that prohibits financial conflicts of interest for the President, the Vice President, the members of the United States House and Senate. Nothing. There's the Emoluments Clause of the Constitution that would prohibit profits and benefits from foreign governments, but that's limited to foreign governments. Everything else we do not have covered in the Constitution or in the statutes of the United States. So when the President says, I can keep my hotels, well, legally he can, as long as he doesn't have foreign government money in there. But is it right? Or did Jimmy Carter do the right thing when he got rid of the peanut farm? And every other president that has avoided personal financial conflicts of interest. And most of the members of the House and Senate, although we continue to have members of the House and Senate who have large holdings in pharmaceutical companies and in the medical device companies and fossil fuel companies, health insurance companies, while they are voting on legislation affecting the fossil fuel industry or the healthcare industry. I have said that that's categorically wrong. And I tried to push very hard to get the current United States House of Representatives to put in its new ethics reform bill, H.R. 1, a provision that would apply the conflict of interest statutes that we have for every other government employee to the members of the United States House, the Senate, and the President and the Vice President, but they didn't want to do it. Because there are several members, and I will not name them right now, who have this predicament, do not want to sell the securities, or have spouses who do not want to sell the securities. That's going to make it very, very hard for this House of Representatives to stand up to Donald Trump and say, well, look at your financial conflicts of interest, if they're not willing to put that in the bill. Now, what we do have in the United States is for everybody in the executive branch, other than the President or the Vice President, we have a criminal statute. It is a crime under 18 United States Code 208. It is a crime for anyone in the executive branch of the United States government to participate in any government matter that has a direct and predictable effect on that person's financial position or investments or those of their spouse. That's a crime under 18 United States Code 208. So, for example, Hank Paulson, who was the former chairman of Goldman Sachs, came into my office to talk about becoming the new Treasury Secretary in 2006. And I introduced myself to Mr. Paulson, and we had a nice, pleasant chat, and he was eager to talk to President Bush. I was the ethics guy, but he wanted to take me seriously, I believe. I said, well, let's chat here. I assume you own some Goldman Sachs stock. Yeah, a little bit. How much? 500 or 600 million. Oh, okay. I felt bad for him because I'm about to tell him he's going to have to sell all of that. You can't have a Treasury Secretary who's sitting on a pile of Goldman Sachs stock. Why? Because as Treasury Secretary, you're going to get involved with regulating or deregulating the investment banking industry. And that would be a federal crime under 18 United States Code 208 if you're sitting on a bunch of Goldman Sachs stock. And an orange jumpsuit doesn't really look too good on a former chairman of Goldman Sachs or former Treasury Secretary. You don't really want to go to jail. So I explained this to him. Okay, I sell the stock. What about the capital gain? Oh, he knows his tax issues there. There's a lot of capital gain on that. $600 million worth of stock, that's $60 million. Well, fortunately, we've got a provision in the Internal Revenue Code that says that the ethics lawyer tells you have to sell it to go into public service. You don't have to pay the capital gains tax yet. You sell it, you buy the rollover property, and you roll the old basis into the new rollover property. You pay the tax later, well, if ever. He liked that. So we had a very good conversation. You know, I had empathy for him. I had not been, you know, I try to understand other people's situation. I'd never been in the situation of having to sell $600 million worth of stock, or $600 worth of stock. But anyway, that's an important provision in the United States Code, but does not apply to the President, the Vice President, and members of Congress. So we've come part of the way in addressing financial conflicts of interest of United States government officials, but we haven't addressed the most powerful, the elected officials. And we need to do that. We also need to address the revolving door in and out of government. People come into government and do everything they can to help their former employer. Now that's tricky though, because you got to decide what kind of government you want. You can have a government similar to what they still have a large part in France, where you know you start as a civil servant. You have most of your career as a civil servant, or you start in the private sector. You don't have a lot of movement back and forth. But the criticism of that model is you have government officials who don't understand business and allegedly don't know what they're doing. I don't know if that's true or not. But in the United States, leaders of both political parties have felt strongly that we need to bring private sector experience into government. So we don't want the model of using predominantly professional civil servants at the very top of government agencies. People come in or political appointees. And we value that experience, but sometimes they know too much about business. And so we struggled with that issue. And I struggled with that issue in the Bush White House. We called it the Goldman Sachs goes to Washington phenomenon, or government Sachs. There's a lot of it in the Clinton administration, and then it was happening again in the Bush administration. People are starting to say, we have another job applicant from Goldman Sachs? I mean, it's getting to be a bit much. The oil industry, going into the Department of Energy, and the coal industry into the Environmental Protection Agency, and we've got a lot of it in the Trump administration. Our controls are relatively weak. We just say if you sell the stock and you don't have any financial ties to your former employer, we're going to assume that you're A-OK and that you're going to make the right decisions. Well, sometimes yes, sometimes no. And we're continuing to struggle with that. And there are trade-offs, as I say, because if you bring people in and you say you can't do anything that affects your former employer, then you might as well use career government, civil servants, because you're going to be bringing people in to work on something they don't know anything about. So this revolving door in and out of government continues to be a problem. My last financial conflict of interest, though, that I want to talk about is the most serious for the United States. And that is campaign finance. If we don't fix our system of campaign finance, all these other conflicts of interest are going to be minuscule compared with the debacle we have awaiting us on campaign finance. And I wrote a book when I was at Harvard for that year in 2014 to 15 called Taxation Only with Representation. And I had it published. I want to get it published quickly before the 2016 election. If you want a book published quickly, the last thing you do is go to an academic press. University of Chicago. It took 5 years with my banking ethics book. So I put this out with Take Back Our Republic in paperback, tried to get the word out that campaign finance was a matter that should be addressed by conservatives, by liberals, by moderates, everybody. It shouldn't be a partisan issue. And a whole chapter in there on foreign infiltration in the United States government through our campaign finance system. Of course, I completely missed the boat because I think I maybe had 2 or 3 sentences about Russia. I was completely obsessed with China. But you know, the next time around it may be China. And China has a lot more wherewithal because they've got the investments. They've got the growing economy. Chinese companies are making enormous investments in the United States. And that's what I was tracking in that chapter of the book. The amount of investments by Chinese companies and Saudi Arabian, Middle Eastern countries in the United States. through various corporate acquisitions. It is illegal for any foreign national to contribute to an American political campaign. I remember giving that speech at the Harvard Faculty Club back in 2014 when I summarized my book. It is illegal for any foreign national to contribute any money to an American political campaign. It's illegal. It's illegal to drink under the age of 21 in the United States. And I said, okay, everyone, when the speech is over, you can walk through Harvard Yard where all those freshmen live on a Saturday night. Mm-hmm. Yeah, it's illegal. Well, try to keep the foreign money, foreign nationals' money out of our campaign finance system the way it's been created by the United States Supreme Court or safeguarded by the United States Supreme Court from congressional regulation. You're not going to. You can't have a huge money party in Washington and say foreign nationals can't show up at the money party. No more than you can have a huge keg party on a college campus and say only people over age 21 can have a beer and everyone else is going to be drinking soda pop. It's not happening. And there are about a dozen ways to get that foreign government money into, and not just foreign government money, foreign nationals' money into American elections. None of that having to do with anything that we've been talking about in the past 2 years with the Russia investigation. We don't fix our campaign finance system. I think it's quite clear the United States is going to revert to the status we had before the Revolutionary War. We will be dominated by other countries. It may not be Great Britain. It may not be a single country, but we will be dominated by multinational conglomerates, including some foreign governments, carving us or our Congress into spheres of influence, just as the European powers and the United States tried to carve up briefly China or the area around Hong Kong and Shanghai into spheres of influence. But it's going to be our turn. We have got to fix our campaign finance system. It is a tragedy. And I want to get back to that because we can talk about Trump till Trump is gone, and I've made that very clear. I hope that's sooner rather than later. But these problems are going to remain with us. And indeed, Donald Trump was the first Republican candidate to come out strongly against the campaign finance system, to condemn the Citizens United opinion. And he was right on that. And then he turned around and he said, all the rest of you guys are bought, whereas I'm not, because I got my own money. Well, the first part, we could argue maybe he was right. The second part, well, we don't know where the money comes. Let's get back to the Emoluments Clause. I don't know. But it's a serious concern. And our campaign finance system will continue to destabilize our politics in the United States unless we address it. Let me turn to investigations, the independence of prosecutors. That's a concern, a great concern here in Canada. And I'm not going to go through the details of the recent scandals here. I'm going to focus on what I still perceive as the much more threatening scandals we've had in the United States. This isn't the first time we've had problems in the United States with the independence of investigators and prosecutors. President Clinton, when he came into office, fired all the United States attorneys. And he has the right to do that because the United States attorneys are appointed by the president. So he fired everybody who had been appointed by George H.W. Bush back in 1993 and replaced them. He was allowed to do it. It caused a fuss because people would like to think that United States attorneys who have the power to prosecute people for crimes, federal crimes that have serious sentences attached to those crimes, they should not merely be political animals. But President Clinton did that. President Bush, George W. Bush, who I served under, there was a scandal there where some United States attorneys who had been appointed by President Bush, according to some United States senators, weren't doing their job very well. What was their job? Their job was supposed to include prosecuting people for election fraud. Translate, prosecute Democrats for alleged election fraud. And so some senators were complaining, so-and-so, the United States attorney in my state needs to be fired because I've been complaining about this or that and I'm not getting any service. And some United States attorneys were fired. Did people come and ask the ethics lawyer about that? No, I get to read about it in the New York Times. I was not very happy about that one. And then there are the more famous episodes in the United States. When I was 12 years old, my father came home and he said there's some big news in Washington. A man named Archie Cox had been fired. Who's Archie Cox? I said, well, he's a famous law professor from Harvard. He became the special prosecutor. What's he doing? He's investigating the president. Oh, well, who fired him? The president. And even at that age, I knew that was wrong. Does that mean I get to go fire the principal of my school? You know, if I get in trouble? And we went through that in the Saturday Night Massacre. And of course, Congress stood up to President Nixon and made it very clear there better be another independent prosecutor to replace Archie Cox. And so in came Leon Jaworski. And then the House and the Senate had hearings looking into the president's obstruction of justice and other high crimes and misdemeanors committed by President Nixon and others in his administration. And by August of 1974, he knew the game was up and he was out of there. But the efforts of the Nixon White House to stop that investigation, to obstruct justice, were very transparent. Now fast forward to 2017, or even during 2016, the FBI had been investigating Russian interference with the American election and whether any Americans were involved. And from the very get-go, President Trump made it clear he wanted that investigation to stop. He wanted the investigation of Michael Flynn, his national security advisor, to stop. And anyone who says that's a nothing burger ought to go back and look at what happened. Michael Flynn lied about his contacts with the Russians. He has pled guilty to felonies. So we have the former national security advisor of the United States, who served all of a couple of weeks, who is a convicted felon. And this investigation has also led to convictions of the president's campaign manager, the deputy campaign manager, and yes, even the coffee boy, who had a Russian handler in England. Now, it is true that none of these convictions were for conspiracy with the Russians. Conspiracy is the operative term. That's the legal term for the crime of conspiring to commit another crime, conspiracy, and no one was convicted for that, conspiring with the Russians. But all sorts of other stuff, including lying about matters having to do with the Russians. And then we got Roger Stone, who's been criminally charged. And this is all in addition to the president's lawyer, who's got some legal difficulties up in New York and is actually pleading guilty and rolling on the president and triggering a Twitter storm, predictably. So this is a serious investigation, regardless of what the findings are, which we do not know yet because we haven't seen the report. But the president from day one made it clear he did not want this investigation to happen. He pressured James Comey, the director of the FBI, to drop the investigation of General Flynn. Comey pushed back. Comey was fired. Why was Comey fired? Well, there's a Justice Department memo drafted by Rod Rosenstein talking about a number of reasons that had nothing to do with why he was fired. We know why he was fired because the president made that very clear in front of television cameras with a Russian ambassador sitting next to him. And it is very clear why Comey was fired. And then Bob Mueller comes in. And then the idea was that Attorney General Jeff Sessions is supposed to rein in Bob Mueller. Jeff Sessions didn't want to do that. And Jeff Sessions, the Attorney General, had his own problem because he'd forgotten how many Russians he'd met. It's not a good idea to forget how many Russians you've met when you're under oath in front of the United States Senate. Senator Al Franken of Minnesota is asking you questions. And then you got busted, and Senator Franken made a lot of noise about that. And, well, suffice to say, the Attorney General, Jeff Sessions, decided he better have nothing to do with this Russia thing. And so he's constantly berated by Donald Trump. Continual efforts to block the investigation. Now, whether this amounts to criminal obstruction of justice, we can talk about in a moment. But it is obvious that President Trump has sought to block the Russia investigation and hinder the Russia investigation in every conceivable way from the very get-go. going to the time when the Trump Tower meeting became public, and that his son, Don Jr., was at the Trump Tower meeting. You got Trump Tower meeting, you got Don Jr., you got Jared Kushner, and you got a woman who's a Russian agent. That doesn't look too good. So, well, what's Don Jr. going to say about this? Well, Dad is going to tell you what to say about it. And whatever he says to the press is what he's going to say to Bob Mueller. So, once again, an effort to stymie the investigation, to block the investigation, to stop it or to steer it away from the truth. Whether or not that's criminal obstruction of justice, separate topic. That's what's been going on there. So a few days ago, Robert Mueller finally submitted his report to the Attorney General of the United States. Right then and there, I saw a problem, and it's a problem I wrote about in USA Today about 6 weeks ago with Jenny Cantor, who is a lawyer at Citizens for Responsibility and Ethics in Washington. I wrote an op-ed on this. William Barr, the Attorney General of the United States, needs to recuse from the Russia investigation. He shouldn't have anything to do with it. He shouldn't be receiving the Mueller report, much less summarizing it or opining on it. Why? Because he's already been in this matter, involved in this matter. In the private sector, he drafted memos for the defense lawyers. He didn't get paid for it. He was kissing up to somebody or trying to get paid for it. I don't know what. He's drafting detailed memos on the Mueller investigation, including on this question of obstruction of justice and how the president can't obstruct justice by doing things like firing James Comey. So he's working on this for the defense. And I interviewed with Donald Trump, met Donald Trump to talk about, this is before the Attorney General's job, to talk about the possibility of being a lawyer for Donald Trump. There's just no way that a lawyer should go from private sector involvement in a particular party matter, such as an investigation, where they're working for the defense, and then go into the government with the prosecution and say, I'm in charge of the prosecution side of this thing. Now, we can talk about ethics rules in the United States, the ABA Model Ethics Rule 1.11, 1.11, revolving door and out of government would address that, but you don't need a rule on that. That's a no-brainer. If you played for the defense in the private sector, you don't come into the United States government and play for the prosecution and supervise the prosecution. He needed to recuse. And instead, what we get is a 4-page summary written by an attorney general with a conflict of interest of the Mueller report. So, first and foremost, we need to see the Mueller report. We need to see the entire thing, not just the summary, the crib sheet prepared by an attorney general who from the very get-go was shilling for the defense and who has a conflict of interest. We need to see the entire thing. We don't know what's in it, but there are two parts to this report. One deals with criminal conspiracy. It does not address collaboration. I don't care how many times Donald Trump or even CNN was running headlines saying no collaboration. No, the New York Times got it right. Robert Mueller has found no evidence, according to the summary, that Robert Mueller would, based on which Robert Mueller would have recommended a criminal prosecution for conspiracy between someone in the Trump campaign and the Russians under our conspiracy statutes. So look at it this way. There's collaboration, and there's a lot of collaboration out there that's legal and maybe unseemly, and then there's criminal conspiracy. And Robert Mueller, according to the summary, did not find enough evidence of criminal conspiracy to justify criminal prosecutions. Now, let's see the report and see what evidence there is of criminal conspiracy and, of course, collaboration. I don't think you can deny there's collaboration. And once again, if you got a meeting in the Trump Tower between the president's son-in-law, and a Russian agent who's coming to talk about dirt on Hillary Clinton, I mean, that just sounds like collaboration to me. But collaboration is not the legal term. Robert Mueller could only recommend prosecution for conspiracy under the federal conspiracy statute and decided based on the evidence he had, to take a pass on that. Okay, that's the first part of the report, but it's been blown way out of proportion. So we have the President of the United States interpreting Attorney General Barr's letter, which then interprets the Mueller report, which we haven't shown, and all this with, obviously, both the President and Attorney General with an enormous conflict of interest. The second part of the Mueller report, according to the Attorney General, addresses obstruction of justice, the same thing that got Richard Nixon in trouble back in 1973 and 1974. I mean, Richard Nixon never ordered the Watergate break-in. He did not participate in a conspiracy prior to the Watergate break-in to break into the Democratic headquarters at the Watergate building. And if we're to believe the Mueller report, nobody in the Trump campaign participated in a criminal conspiracy with the Russians to break into DNC emails. It's just a high-tech version of what happened to Watergate, but you got email and computers, and you got ex-KGB who are heading things up instead of the novices, the handful of Cuban emigres who were novice burglars who didn't even know what to do with a masking tape back in 1971 or whatever they would break in. But, you know, okay, you don't have conspiracy there that involves the president, but obstruction of justice is what brought down Nixon. So what about obstruction of justice? Now, the thing with Nixon is we never developed case law on that. Can the president obstruct justice? Why not? Because President Ford gave him a pardon. That cost President Ford the election in 1976, but his successor, President Ford, gave him a pardon, so we never had a trial for President Nixon for obstruction of justice. And one of the issues that might have been addressed in that trial, although his pattern of obstruction of justice was different than what's been going on with Trump, but one of the issues that might very well have been addressed is how does the power of the presidency, as defined in the Constitution, affect our definition of the crime of obstruction of justice when it is allegedly committed by the President of the United States? Because there are theories which I disagree with, of American constitutional law that view the president as the head of a unitary executive. And so you've got the Attorney General who works the president and conducts the investigations the president wants him to conduct. If the president wants to turn the switch off on an investigation and flip that switch off, it's off. Because we have one executive with one person at its head, and the Attorney General works for the president. And there are those that adhere to that theory. And indeed, the Attorney General of the United States has made it clear that he adheres to that theory, and he made that clear over and over again. That's why he got the gig, right? That's how he got the job. And there are constitutional law scholars that adhere to that theory. I'm not going to say it is completely ridiculous. I say it's wrong. I strongly disagree with it. That we thought the American Revolution for a reason. That yes, in European law, in many countries, the king could not violate the law because the law was the king, and the king made the law, so the king could not violate the law. But we had a revolution. We don't have a king. We have a president, and the founders did not want to simply elect a king for 4 years. Put a little gold crown on his head. That's not what the founders wanted. And so this theory of the unitary executive, in my view, makes the president too much like a king. Okay, that is an issue of constitutional law and interpretation. I strongly disagree with that theory, but I believe Robert Mueller was right in taking a pass on that. That he can't make that call. He can lay out all of the evidence, which Attorney General Barr has not shown us, of obstruction of justice by the President of the United States. Evidence that would clearly lead to, I mean, we'll see, but I believe, based just on what I've seen, lead to an indictment for obstruction of justice if it were anybody but the President. And what we have standing between Donald Trump and that indictment is this unitary executive theory. This view that the President has the power to simply throw the switch off on that investigation. And therefore, he can't obstruct his own investigation. In fact, he'd be obstructing himself The president cannot obstruct justice. That's the theory. Robert Mueller did not want to contend with that and said, here's the arguments. We don't get to see them yet, and I'm going to take a pass on it. Now, there'd be no point in his saying anything about it anyway. Do you know why? Because there's a whole other issue, which is whether a sitting president can be indicted for anything. That's another constitutional debate. I believe the answer ought to be yes, that the Constitution does not say that a president cannot be indicted while in office. And why would we make that rule up? But there are those, including constitutional law scholars, who say, no, the only way to deal with a president who's committed a crime is to impeach first, then, or wait till he's out of office, and then indict. You can't indict a sitting president. So yes, Donald Trump could shoot somebody in the middle of Fifth Avenue, and he said he could. And once he became president, I guess he's right. He couldn't be indicted because he's the president. You'd have to impeach first, 2/3 of the Senate votes removed, then you can indict. The position of the United States Department of Justice is that a sitting president cannot be indicted. So right there, you'd have two roadblocks to the prosecution of Donald Trump for obstruction of justice. One, the unitary executive theory saying the president can't obstruct justice, so you could never prosecute Donald Trump for what he did. And the second, the view of the Department of Justice, which the Attorney General of the United States, of course, agrees with. I'm sure he said he agreed with it to get the job, that a sitting president could never be indicted. So Robert Mueller takes a pass on that and says, well, I'm going to lay out the arguments, and then this is to be resolved. In this case, it's going to have to be resolved by the United States House of Representatives, Judiciary Committee, because that's where the power of impeachment lies. This president will not be prosecuted by this Justice Department for obstruction of justice. That is a possibility in January 2021, that you might have a new Attorney General, and the statute of limitations, I believe, is 5 years, so there's some exposure there. I have strongly discouraged any Democratic candidates from talking about that, because the last thing I want is another nutcake out there saying they're going to lock up their political opponents. We don't do that in the United States, and that's one of the things that really, really angered me about Donald Trump. So we've had a very, very challenging experience in the United States. I want to have some time for questions. And I didn't address the scandal here with the Prime Minister and the pressure put on a prosecutor. We've had a lot of that in the United States. Some company gives a lot of money to political campaigns, and then this pressure being put on the prosecutors to drop the case. I told the Bush administration, White House, anybody calls the Department of Justice about any open cases out of this White House without coming through my office, I'm going to resign. Because that stuff had been going on in the Nixon years, and going on in the Reagan-Bush years, and it was happening in the Clinton years. So we've had it. We've gone through that. And I know you're going through that debate right now about how to handle that. But prosecutions and investigations need to be independent. If they're not, we have no rule of law in Canada or in the United States. I want to have some questions and discussion here.
Thank you very much, Richard. And
thank you, Paul.
Again, just as a reminder, there are some index cards being circulated. Please feel free to write out some questions. If you want us collecting them, and we'll bring them down to the front. We've got a lot that we can talk about. There's a lot in there, both in terms of finance and campaigns and political observations. Let me start off, actually, Richard, with a little bit of a curveball. Personally, in terms of serving as a commentator, you're one of the ones that's most prominent on CNN, MSNBC, and otherwise. What's that done in terms of your relationship with your political constituency, with others, and how have you found yourself either empowered or constrained by the media that you're appearing on?
Well, the advantage of the cable news networks, they do reach a broad audience. And so you obviously reach more people than you would on the local television or radio, even NPR, National Public Radio, or Minnesota Public Radio. There are two problems with cable TV. And the big ones are Fox News, we all know about them, MSNBC, and CNN. One problem is that you usually get about 1 minute to say whatever you think on something. Now, I believe I've gotten down to a bit of a science there, the ability to say the most about something in 1 minute. And I wouldn't be as long-winded as I have been with you today. So I get some stuff in there. But you don't get much time. You get a lot more time the times I've been on National Public Radio or on public television. You get more time for analysis. The second problem is the cable news audiences have become segmented according to political ideology, and I don't think that's good for our country. When I was growing up in the United States, you had three major networks, ABC, NBC, and CBS, and the nightly news. My dad liked Walter Cronkite and Dan Rather, so that's what we'd watch, but even more liked public television, so we'd then flip over to that. That was the other alternative. So you'd say public television was the really educated person's alternative, and the rest was, just the standard package. But everybody watched it. You could be a left-winger or a right-winger. You watched, one of the three major networks. And they weren't segmented politically. So what we got going on in the United States, people are getting their news from different sources. And that's exactly why I make an effort. If Tucker Carlson calls me, I say, yeah, I'm coming on. I give him a fistful of it. And, I'll go on any of them because I think it's very, very important to have views that are given, where everybody's getting the news. And that's not what's going on right now. People are getting the news they want to hear.
Question coming in whether or not you've got any particular ethical concerns with and I'm going from the card here, with the primary source of alleged collusion with the Russians and interference in the presidential election being the Hillary Clinton campaign.
Well, the Hillary Clinton campaign provided some evidence, but there's a lot of evidence, and we'll see this in the Muller Report. When prosecutors get evidence in all sorts of different places. I mean, think about it, you're prosecuting the mob. I'm not going to compare the Hillary Clinton campaign to a mob operation, but if you're prosecuting the mob, you get evidence from other mobsters. So if you're prosecuting political campaigns that allegedly colluded with someone who was spying on the the opposite political campaign, you're obviously going to get some information from them too. Now, I think the Hillary Clinton campaign was, I had my issues with them, but I generally thought it was reasonably well run. But the point is, you're going to get your evidence everywhere. I mean, think about all the evidence we're getting from Michael Cohen. I mean, he's a convicted felon, and President Trump would make a big deal about that. But that's where evidence comes from. You usually, when you're prosecuting bad guys, you don't usually go get all your evidence from, choir boys.
Few questions coming in about the Supreme Court and the manner in which the politicization of appointing justices to the Supreme Court has had an impact on what you're seeing in terms of confidence in the institutions in the United States. Would you care to comment on that, and in particular in light of the recent confirmation hearings?
Yeah, that's been a problem over several decades. And so that's not a problem that I'd say is unique to the Trump administration, the politicization of Supreme Court confirmations. That's been going back even when I don't really remember it, when I was 6 years old, but I was told about it. They put up signs all over I was growing up in Kansas, impeach Earl Warren. Earl Warren was a Republican governor of California who became Chief Justice of the United States Supreme Court and decided the 1954 Brown versus Board of Topeka, Kansas case and got the court unanimously to overturn school segregation. And people are mad at him because those cases and some other cases are perceived as way too liberal in judicial activism. So we have had a political environment surrounding the Supreme Court appointments for a long time. Even during FDR it was this way. FDR got so upset with the Supreme Court, he said he was going to add some justices. I noticed some Democratic candidates for president who were talking about that. It is a serious concern in the United States. The Supreme Court becomes too political. We had Chief Justice Roberts out to the University of Minnesota Law School, talked with him about it. I do think that cases like Citizens United, where the Supreme Court overturns Congress's legislation concerning campaign finance, that's asking for trouble. That is one of the most unpopular decisions, probably the most unpopular decision of this court in the past 100 years, the Citizens United decision. and they're getting involved in something they don't know anything about. None of them have run for elected office, and they try to define what's a bribe in politics, and they don't have the foggiest idea what they're doing. That, and of course, the arguments about abortion. And really the best answer to that is, if you make a controversial decision, such as Roe versus Wade in 1973, you better have a very, very good reason to turn around on something like that. And the Supreme Court, if they were to emphasize the importance of stare decisis and make it clear that they're not going to be turned around by politics, there'd be a lot less of that, because people who are then trying to change the composition of the court for that reason might invest elsewhere. But it's a very serious problem in the United States.
Question about the usage of the pardon power, and in terms of continuing conflicts of interest, whether or not you see just both in general the use of the pardon creating a conflict of interest for the president, and whether or not in this particular case it's created particular issues for you.
We need to read the Muller Report, because one of the allegations of obstruction of justice that has been made against President Trump is that he's been dangling pardons with a number of people. Lawyers have talked to other lawyers about the possibility of getting a pardon, and that these discussions have taken place with people who are material witnesses in an ongoing investigation. I mean, if I talk to a material witness in an ongoing investigation, which I have an interest, about a business deal in which that witness is going to get a bunch of money, I'm going to get nailed for witness tampering. Why does the President of the United States have a right to have his lawyers talk to their lawyers about pardons? So there's the obstruction of justice component. When we read the full Mueller report, which we better get soon, people are going to be pretty upset. We're going to address that, and that's just the beginning. We get into the issue then of what if he pardons himself? Now, in a paper with Lawrence Tribe, Norm Eisen, we took the position that the president cannot pardon himself. And that's just the word pardon. A pardon involves two people. All right? Or if it in my faith, in the church, you're pardoned by God. I'm Protestant, so you don't go to the priest for pardon. You ask for God for pardon. But you have either two people or person and God. That's it. Not one individual who is a mere mortal. Yes, he is a mere mortal. Pardoning himself. That's just not the definition of the word pardon. So that's the position I take on it. But there are others who have a different view.
We could have a really interesting conversation at the reception about the relationship between Trump and God and whether or not it's one and the same. But the triune God takes on different definitions for different people.
Well, I know that Rob Mueller was praying in church on Sunday morning. Right opposite the White House. A great shot of him walking out there with the White House in the background.
Yeah, actually noticed that. Do you think he was sending a message?
I think he was, maybe. Well, that's the church he goes to all the time anyway.
Okay. That's
actually the last place I saw him. That church was a little yellow church right across from the White House. But he hadn't been seen, though. I mean, I think once he did his work, he didn't tend to go out in public. Or at least maybe he'd sneak into church in the back or something.
Apparently drives and wears a baseball cap like some of the rest of us. But yeah. One of the interesting things about Mueller and the manner in which he managed the entire process was that it was considered quite remarkable that it was leak-free. What do you think, somebody's asking the question, what are the chances of the Mueller report, if it's not indeed released by the Attorney General or otherwise, about the report being leaked?
Bob Mueller won't leak it, but it's going to come out because Congress is going to subpoena it. And the longer they drag this out, the worse it's going to be. It will be devastating for President Trump in the elections coming up if they don't release the entire Mueller report. I mean, he has dominated the news cycle in the past 24, 48 hours over this, screaming no collusion. But the bottom line is that there are a lot of open questions here, and if we don't get the Mueller report, there's going to be a lot of trouble. The other thing is if it's released just to Congress, it'll leak out of there big time. And so, it comes out in drips and drabs, and that's going to be the absolute worst situation. Or the Trump administration would do the smart thing, which is to put all the cards on the table, give us a report. We can read. We don't need the crib sheet 4-page crib sheet prepared by an attorney general who has a conflict of interest and who interviewed for the job, basically saying the same things that he said in that crib sheet.
I didn't get a chance to see SNL on the weekend, but I'm looking forward to Alec Baldwin reading the 4 pages. Neat segue, actually, talking about members of Congress. What faith do you have in congressional investigations, and what do you see as the path going forward for the investigations that are either launched or about to be launched?
Generally, Democrats are extremely thorough in investigating Republicans. Republicans are extremely thorough. Indeed, I thought in the years 2013 to 16, excessively thorough in investigating Democrats, including misuse of a wrong email server, something that I chewed people out for in the Bush White House, but nobody called the FBI because it just doesn't rise to the FBI level of offense to use the wrong email server. But so the problem we have is that when it involves your own party, you do nothing. The investigation, any investigation, is a waste of taxpayer dollars. We're already hearing this. People saying the Muller investigation is a waste of $25 million. Wait, if the Russians interfered in an American election, this is an adversary that we spent trillions of dollars competing with during the course of the Cold War, and that has tried to destabilize Western democracies for 100 years. And it's a waste to spend $25 million having Bob Mueller trying to find out what was going on? I mean, I don't know how much military equipment $25 million buys you, not very much. You know, this is where we're going to lose the Cold War, is this kind of thing. So that was money well spent. So the point is that when it's investigating your own party, every investigation is a waste of taxpayer money. Let's talk about the issues. When it's investigating the other party, well, we're going to nitpick everything. And they both do it. And there's an incentive to do it. So I think to fix this, we need to have investigations in Congress. You know, one thing I suggested, the subpoena power ought to belong to the minority, not just the majority. The Democrats in the Senate, in the House and the Senate, should be able to serve subpoenas during those first 2 years. And now the Democrats in the Senate should be able to serve subpoenas. You shouldn't have to control the chamber to serve subpoenas and investigate people. So we can fix some of this. But right now, the investigation process is very politicized, except for someone like Bob Mueller, who just calls it right as he ways he sees it. And you know, that's the other approach, is turn investigators over to professionals. Have an independent prosecutor statute. We had one after Nixon, and we had an independent prosecutor statute, but it had an expiration period. It expired right about the time you had a guy named Ken Starr. He had been appointed special prosecutor to investigate an Arkansas land deal called Whitewater. And by the time he's finished, he's investigating the president. Well, we know what the president did. But, you know, it just didn't have anything to do with the Arkansas land deal. People were a little upset. So they let the statute expire. So for this entire 2 years, almost 2 years, we've been right back where we were in the Nixon days, where when I went on some of those television channels, they called me in about, we're going to have another Saturday Night Massacre, and Mueller's going to get fired. It's like, this is Archie Cox all over again. I have an article in the Concord Monitor, Concord, New Hampshire. They both went actually to the same high school, 40 years apart, with their yearbook pages. These were clean yearbook pages, I guarantee you. Archie Cox, Bob Mueller, none of that hanky-panky stuff. And, you know, but these guys, you know, you have independent prosecutors who could be fired. That's just not right. We need that independent counsel statute back, so we don't have to worry about someone like Bob Mueller getting fired.
Another question that's come in on the personal side, asking you to discuss your move from the Republican Party to the Democrat. And what was your journey in that regard? And when you talk about investigating the other side, how does that translate for you now?
Yeah, and right now I'm actually an independent. And I made that clear when I ran the Democratic Farmer Labor Party primary in Minnesota for the Senate unsuccessfully, that I'm an independent. I would have caucused with the Democrats and represented Minnesota if I'd won as a Democrat in the Senate. But my political leanings are independent because I do not like the way the parties do business. And I was with the Republican Party for a long time. I was a moderate. People call you a liberal or a rhino if you're a moderate Republican. And if I were in the Democratic Party, I'd be a moderate Democrat. But I really prefer, I call myself an independent because one of the problems in the political parties is you're expected to be loyal to your own team. You're there for the blue team or you're there for the red team. And that's just wrong. I believe you need to call the shots the way you see them. And you may agree with one party more on issues than the other. And yes, if you looked at today's Republican Party, where the majority of them are, and where the majority of the Democrats are, on issues, I probably agree with the majority of the Democrats in the House and Senate when they vote on issues, as opposed to the Republicans usually, just because that's where the Republican Party has drifted. I wouldn't have said that 25 years ago, and I don't think that's about me changing. I mean, we all change somewhat, but it's about the fundamental shift in particularly the Republican Party in the United States. But I think to me, a party affiliation means you're loyal to your own team, and you're going to overlook corruption. As an ethics lawyer, I can't be a partisan. I mean, that was tough enough for me in the Bush White House when I was a Republican. And I'd say, you can't do that. I said, well, it's important to the Republican National Committee. I don't care if it's important to the Republican National Committee. You can't do that. That's the way I am.
That begs the question that some have actually been talking about recently, and I know that you've been involved in some conversations. Is there room for a third party in the United States? And do you see it happening?
We need ranked choice voting in the United States, where you could pick a first choice candidate and then a second choice candidate. Because otherwise, third parties could throw the election one way or the other. I would have run as an independent for the Minnesota Senate seat. That was my preferred course. Then I would have run all the way to November. But a number of people said if I'd run all the way to November, the November election as a third-party candidate, given my negative views about President Trump, I would have split the vote with the Democratic candidate, Senator Tina Smith, who was not as opposed to Donald Trump as I am, but certainly no fan of Donald Trump. And that would have put a Republican into Al Franken's seat for the next 2 years. And I just felt I couldn't do that I'd be viewed as a spoiler. So I had to go into a primary and say, okay, I want to advance my views on some issues in a primary, and I'm going to choose the Democratic primary. I don't know if I could have gotten out of a Republican Party meeting alive in this environment. You know, I got those Second Amendment people running around. So I chose the Democratic primary. But the problem is that you could throw the vote. You could spoil the election as a third-party candidate. So you've got to choose one of the two if you're going to run, unless you want to risk spoiling the election. Now, if you have a centrist third party, that could work, a new centrist third party. But so far, the third parties have been sort of on the fringes. Centrist third party could work, but what we really need is ranked choice voting. You pick a first choice. If your first choice gets knocked out, doesn't get enough votes, your second choice counts. You could, you know, and you could have chosen Jill Stein, the Green candidate, first choice, and then Hillary Clinton. Or in 2000, we had the same thing in 2000. Your third party, Ralph Nader, down in Florida. Enough people voted for Ralph Nader instead of Al Gore that George W. Bush went to the White House. So if people remember that. So that's the problem with third parties in the United States.
What were some of the greatest challenges you faced, personally and professionally, as a White House ethics lawyer?
One of the most difficult challenges is this idea of loyalty to the president. I believe that if you serve in the White House, you should be loyal to the president in his official capacity, his or her official capacity in carrying out the duties of the presidency. And that does involve some decisions the president makes about policy. If you don't agree with the president's immigration policy, you can advance your views, and if the president disagrees, you get out. The president has the right to make calls on policy issues. But when it comes to ethics, in situations where people are doing things that are unethical, far too often what you find is not, certainly in the Bush administration, isn't the president making the calls, but it's somebody the president has delegated a job to for running political affairs or whatever it is. And the idea is if you don't rule on this ethics, if you don't interpret the ethics rule a certain way, that's going to make things harder for the president. Well, I don't view it that way. When you're talking about the law and what the rules are as opposed to policy, the job of an ethics lawyer is to say what the law is. And also if there's something that is legal but would look terrible, to make it very clear that that's my view. So the idea that the ethics lawyer needs to be a team player, I find very, very problematic. And it's not just in the White House. It's in every corporation in America out there. You're the corporate ethics lawyer, the compliance counsel. You're not a team player. That's what brought down Wall Street in 2008. I mean, I've written a lot about that in my book on bankers' ethics in 2000, when I published that book in 2015. It's a big concern. I think if you're an ethics lawyer or a compliance counsel, you're not there to be a team player. You're there to do your job.
Final question, because it came up on a number of different cards, and I'll put it very simply. 2020, predictions.
Well, I don't like to get into too much of that. I hope whoever is run, by both parties, they could run a man or woman of character. And I think I've made clear my view about what ought to happen in the Republican Party. And every time someone talks about a primary challenge, I'm there cheering them on. I think there needs to be a contested primary. Just because you're the President of the United States doesn't mean there shouldn't be a contested primary. And in this case, we need one on the Republican side. And then on the Democratic side, you've got to have a lot of good people. I hope they can focus on issues and on what's wrong with the Trump presidency and not be attacking each other all the time. We'll just see where this comes out. We have a good field of candidates, at least on one side, and we have some good potentials who could jump into the Republican side if they aren't scared off by the Republican National Committee doesn't even want to have a primary. And I think down in South Carolina, they've already announced there's not going to be a primary. I mean, that just isn't the way a democracy ought to be run.
There are a number of questions we didn't have a chance to get to, but I hope that you'll join us upstairs at the reception and put them to Professor Painter himself. In the meantime, please join me in thanking Richard Painter for his remarks this afternoon.
Thank you. Thank you.
Thank you very much, everybody, for coming. Safe travels if you're heading onward. Otherwise, we hope to see you upstairs in a few moments.